Welcome. I am Dr. Patrice Berry, licensed clinical psychologist, and here I share legal and entertainment news from a psychological perspective. Today, I've been following the Christopher Gregor case. Please check out my other coverage on this case if you, but I think most people here, we all kind of know where we are. He is on trial for because he's been charged with the murder of his son, Corey. And some things happened today in court that I wanted for us to get to talk about because he messed up. And I think his lawyer knows it. His father testified earlier today. So I covered the father and mother's testimony outside of the presence of the jury. Today's testimony, his father testified in front of the jury. It was very similar to that other testimony that I have already covered. So I won't be going back through that. But I did want to share because his mother is not going to be testifying, and it's because of something he did. So let's hop into this right now.
Sir. Now, do you want to?
So before we get to any of those issues, Mr. David Gregor came into courtroom. Since he's testified, any objection to that by either side?
No, Judge, but
So right now they're talking because the father is so Christopher's father is in the courtroom, and the camera is going to pan to him a little bit later, but the state is okay with the father being in the courtroom.
Did that go for the same for our witnesses too? Because we've been telling them not to come to the courtroom. So
at this point, I doubt very much that I'm ever going to call Rebecca Micholo. Can you give me till the end of the day to make a decision?
well, I just want to make sure that if he, that we're telling our witnesses the correct thing too, because we've told everybody technically the trial is not over. They're still under sequestration. So
Right. The defendant always has the ability to recall the state's witness.
right.
David Gregor was the defense witness.
Right.
You're going to call him, so, and the defense has already called him, so. I'm just
Judge,
pointing out that he's here, and I want to make sure, but given these unique scheduling and evidentiary issues, I don't think I can put pressure on Mr. Gallucci to say right now he's not going to recall the state's witness. We did, in fact, talk about whether he would recall Detective Sergeant Coles at one point. So I think you're making the right decision by telling your witnesses at this point there's still a sequestration order in effect.
Thank you, Judge.
All right. So you want me to hear from the state as the issues you just brought up, and then we'll talk about the other issues?
Sure.
All right, what's the state's position on, first of all, any problem with the three police officers tomorrow at this point, assuming they're okay?
No problem with the officers. The Detective Mitchell, Officer Dugan, Officer Roman will all be here at 8:30 in the morning tomorrow, subject to any conversation Mr. Gallucci has with them otherwise.
Good.
And then we're assisting with the Seabright issue as well. With regard to these body cameras, we would like a chance to go back and review the full camera. There are a number of cameras from different angles, from different portions of the interaction. And this particular one, Flock Video 2, that counsel pointed out is 2 hours long. And it's a snippet. It's not the whole story. It's not everything that's happening. So Ms. Lento and I need to review it, decide what we want to agree to, if we want to ask that the whole thing maybe be played instead of just 3 minutes of it, or if we want to do it by way of a stipulation. But we need a chance to speak together and look at it in order to make that determination. We also have a transcript of it. We want to go back and look at the transcript as well, and then we'll confer with Mr. Gallucci, and maybe we can all agree on something. At this point, I don't have an answer to that.
All right, and you want to do that privately? You don't want to play the whole thing in court, you're saying, or are you saying that?
We want to speak at least privately.
Judge,
Right. I'm saying, are you proposing that you want to play the 2 hours in court, or that the two of you
We
want
don't
to
need
do
to
it
do
privately?
that in court. No, we can go back to our office, and then we can either talk to Mr. Gallucci in person, on the phone, whatever we need to do.
So I perceive that the only real evidentiary issues are what's admissible from the video. Theoretically, one or both of you could.
So this is where the court camera, I'm looking, so Christopher Gregor called his mom and they recorded that tape. So that's the part that we're going to get to in just a moment.
Compel a Tennessee police officer to come here to testify for just few moments about what his position is, that he was there, and the video accurately depicts the events that it recorded that day.
Judge,
So
that's
the-
absolutely correct, and we made a decision
Right.
not to do
All right,
that.
so thank you for
State
that.
made
So
the
the authentication issue is really relatively simple. It's whether or not hearsay statements on the video are permitted to be played, and if so, what statements are permitted to be played. If you needed some instruction that they're not for the truth of the matter, but they're to establish the defendant's demeanor or conduct or behavior on that date, I could obviously try to craft that instruction for you in that regard.
And Your Honor, I'm sorry, I think I misspoke. What I was saying was that the state made the decision that we were not going to try to call somebody from Alcoa in our case to try to proffer any portion of that video. That's what I meant.
Okay.
I know, I don't think it was responsive to the court.
No, actually, I didn't understand you then. I took your position to mean that you weren't going to dispute the authentication of the video.
That's,
I'm just gonna
that's
fast
part of-
forward a little.
We want to talk.
All right, so I'll give you an opportunity to do that later. Now, the next issue is the decision to call or not call Carolyn Gregor, the defendant's mother. Who would like to begin with that issue?
Judge, I can begin. The state came into possession of a recording of a phone call between the defendant and his mother that took place, I believe, last Friday, subsequent to the testimony of Carolyn and David Gregor at the 104 hearing in this court.
So just to clarify, after the hearing where the mother and father testified outside of the presence of the jury, Christopher called his mom from jail and they have a recording of this call. And let's keep going.
The phone call, the state asserts that the defendant was coaching his mother with regard to her testimony. I sent it to the court. I sent it to Mr. Gallucci last night and indicated that if Ms. Gregor testified, or even in the defendant's testimony, basically anybody that makes that relevant before the court, I will, subject to any rulings from the court, be looking to use that on cross-examination.
So he called his mom, and the allegation is that he wanted, and so we don't know exactly what happened on the phone call. That did not come up today. What came up is that if the defense does call his mom, then they were going to bring up whatever was said on this tape. And I'm guessing whatever was said was problematic because the defense is going to bring up the fact that his mom repeatedly tried to get him to change the subject. Lamisha, I see your comment and I'm going to come back to it once we get through this part.
In whatever form I need to at the time.
Thank you, Mr. Gallucci.
Your Honor, as you know, I'm in charge of making the decisions on who the witnesses are going to be that testify in court. And what Ms. Schroen just said is very accurate. I received not only a transcript of that recording, but also the recording itself. I don't necessarily disagree with Ms. Schroen's interpretation of that conversation, but that conversation.
So the defense attorney, to me, he's approaching this in a very soft manner, I think, for his client, and he's not wanting to upset the court or the judge because he can have a very aggressive style sometimes. And right now he's being very soft spoken and he's being very soft spoken right now. Olivia, I think it would have come up if this was death penalty eligible. I don't think the state is going for that. I think he's facing up to life in prison. I know that because the state offered him a deal before the trial to serve 30 years, but he would have to serve all 30. And so I believe he's facing 30 years to life if he's convicted of the murder trial, of the murder case. The murder charge. That's my understanding of it.
Does make me not want to call Mrs. Gregor as a witness in the trial. I will say that at every single moment she had the opportunity to stop her son from speaking about the case and trial strategy and whatever else you wanted to discuss.
the defense attorney is probably frustrated with him in this moment because he kind of said, try, like, I think Christopher made this decision all on his own. And this is making the defense attorney's job a lot harder, a lot harder.
Discussed, she made every attempt to stop him from talking about it, but he persisted. And at one point, actually, even hung up on her son because he continued to persist. At one point, you actually hear his father in the background saying, "Stop," and basically, enough is enough.
I don't want to make light of that. She hung up. Whatever he said, I think they knew it was so wrong that the mom ended the call. And at some point, the father, I guess, is in the background saying, like, because everybody knows these calls are recorded and monitored. And the minute whoever's listening to these calls hears the defendant talk about the case, they are going to, like, they're going to let the prosecution and the defense know. That's why these calls are recorded. And so I'm guessing he didn't even try to do it in a sneaky way. So it was Jessie Kershkeshki, Jessie K. Y'all know I can't say her last name. That case, she tried to, like, write a like, she tried to, like, it's my the allegation was that she was trying to communicate with her mom in a way to elicit some testimony that was not accurate. There was another, the walking the dog. Was that Corey Richins? I want to say that was Corey Richins. She also kind of wrote something that was kind of a roundabout way, trying to say, the allegation is that she was trying to elicit false testimony. Yeah, the walk the dog letter. I believe that's Corey Richins. I could be wrong. Me and names, not great. But I have to go back. Like, and her, I think he wanted her testimony to be even stronger for him. And if his mom was trying to get him off the phone, my guess, and I don't know this for sure, my guess is he might have been asking her to maybe not tell the truth, because he could have told his attorney whatever he was trying to elicit from her, and his attorney could have asked the question if it was the truth. Like, it sounds like he was trying to get her to change her testimony. Is that Corey's new book? Because she tried to say that it was fiction. Whatever she wrote, whatever it was, the walk the dog, and her trial will be starting soon. I think it'll be starting soon. I'll definitely be covering that one. That one is very heartbreaking. I really feel for the children in that case, because they have lost their father, and there's a good chance that their mom might be going away. And so that's just very, very heartbreaking.
So as a result of this conversation, I find it necessary not to call Mrs. Gregor as a witness in this case. Mrs.
So the defense is not going to call. This phone call must be extremely prejudicial. Like, it must be not prejudicial. That might not be the word. It must be it must be really bad for the defense, whatever was said, that we have no clue what was said.
Mrs. Gregor was going to be a fact witness, and basically testify, not even as long as Mr. David Gregor testified, but she would have testified basically to conversations she had with her son the morning that Corey had come home. So it was going to be a very limited examination anyway. So as a result of this conversation that my client was involved with.
So the interesting thing, because the mother's testimony was going to say that Corey was tired, that Christopher called her, and she encouraged him to just let Corey rest. So that was the testimony that they were going to try to get in. Hey, it's a pop-up. So I had a quick minute, and this messy stuff happened in court. I could not wait until Saturday to go live and talk about this one. I just couldn't wait. I just couldn't wait.
I will not be calling Mrs. Gregor.
All right, thank you both for that. Ms. Sharon emailed the court with a copy, obviously to Mr. Gallucci, containing a transcript of the recorded telephone call, and indicated that she intended to seek permission to be able to use the same. And first thing this morning, Mr. Gallucci asked for the ability to conference the matter, which we discussed in chambers, but everything that's been discussed in chambers has been repeated out here in detail. The court agrees with what counsel have said. It's well settled law that any attempts by a defendant to influence, change, or alter the testimony of a witness, whether that be through threats or promises or entreaties or otherwise, can be admissible. In fact, it can be admissible on the issue of consciousness of guilt.
Yep.
I've already gone through a long analysis on the admissibility of post-offense evidence regarding consciousness of guilt, namely the defendant's alleged flight to Arkansas and Tennessee, his alleged deletion of internet history and text messages. So in that regard, I would have had to make a decision about not only the ability to cross-examine defense witnesses, such as Ms. Gregor, on what influence the defendant's conduct may have had on her, but whether or not that conduct also would be separately admissible by itself. Our Supreme Court has recognized that the relevance of post-offense conduct to a defendant's mental state is important, and courts should address it if it demonstrates a consciousness of guilt. And again, I'll cite State versus Williams, 190, New Jersey 114 at 125. That's a 2007 New Jersey Supreme Court case.
I think they know this is not going well. I think they know, and I think Chris knows it, but you don't try to change someone's testimony. You just can't do that. That's illegal.
The case I cited last week in regard to other post-offense conduct evidence. And in that Williams case, statements made by the defendant towards witnesses to get them to alter or change their testimony were deemed admissible as the defendant's intent. So here, the defendant evidently was still foolish enough to try and engage in that conduct, even while the attorney was obviously meeting and preparing the witnesses. Both sides have correctly summarized the statement. The statement ends, the phone call ends with Mr. David Gregor intervening and saying the conversation's over. In fact, he even says that they've been meeting with Mr. Gallucci, which was appropriate, and there's no reason to continue the call. And then both parents repeatedly say that this is the end of the call. It's over. Stop. So Mr. Gallucci's then been put in a situation to have to make a decision how to address that. I'm a firm believer in allowing attorneys on both sides to formulate trial strategy. The attorneys have access to all of the discovery materials, unlike the court, and attorneys have to make strategic choices both in advance of trial and during trial. One of the things that I often cite to is that
When things that look, and people really resonated with the menacing word, the way that he just looks, and I just wonder how that's coming across with the jury. He comes across looking just mean and angry. And the only time he softened was when he saw his mom. That was the softest I saw his face. And then initially when he saw his dad for the hearing, I think it was last Thursday. I could be wrong on the day, but the hearing last week. And I am going to get to the questions in the chat.
trials are not perfectly scripted or choreographed theatrical presentations. They're more of an extemporaneous production whose course is often unpredictable given human conduct. Attorneys will sometimes be confronted with inadmissible evidence coming to the attention of the jury, or attorneys will sometimes be confronted with witnesses not being predictable, particularly in criminal cases such as this one, because in criminal cases, there's no pretrial depositions like there are in civil cases. Witnesses may say things on the stand different than their prior testimony, or they may also sometimes be subject to outside information, which could influence their testimony. And both sides have to try and react to that. And this is an example of both sides doing that. Our Supreme Court discussed that the trial is not a perfectly scripted presentation in State versus Yaw, YOUGA.
And so he's going to go through the law. So pretty much what's going to happen is that Christopher's mother is not going to testify. The defense has decided to not call her. And that's largely because if they call her and she testifies, the state is going to play the tape of him trying to coach her testimony, which is illegal. It sounds like it can only come up if they call the mom, because it was specifically about her testimony, and it sounds like it was something specific that he wanted her to say. And so it will only come up if she was called, and the defense has decided not to call her. The state did say that if there's something similar, like if something comes up that might be related to what he said on the tape. So let's say he tries to testify to something that he was trying to get his mom to say. So let's say Christopher decides to testify for in this case, and he tries to say whatever he was trying to get his mom to say. Then the prosecution might then say that they want to admit that as evidence, and the defense would object because it's probably not good for their client, whatever was said, and they would go from there. Okay, so Mammy Bell, you are seeing some almost embarrassment from him. And I really like Dr. G Explains video where he went over the treadmill video, because in that video, you don't see Christopher. He doesn't look ashamed, or like he doesn't come across, there's no like, he doesn't look away. Like it's hard for him to watch that, which was just very, very strange to me personally. But not if somebody has these more, if they have some possible personality traits, or if they are trying to get their way at any cost. And at first I wasn't sure how to kind of take the judge in this case, but I think the judge is trying to stay as balanced as possible. I do think Christopher's father is probably, because the mom's testimony could have possibly helped him in some ways. I don't think it helped a lot. Somebody did ask a question. I want to go back up to this question because an anonymous source did reach out that is close with Brianna's family, with Brianna's side. And that source did confirm, according to their allegation. I don't know how credible this information is. I don't know how credible the source is, but they did confirm that Christopher and Brianna were never in a relationship, and that it was not consensual. That's according to that particular source. And I have that comment pinned on my last video as well, because I didn't go into that part, but I did go into the fact that because there's a lot of information about Brianna's substance abuse or substance use. And that source was like, she wasn't using every day. She never used in front of Corey, and that she's kind of being painted as like a junkie. And the person was like, that was not at all the case. And so, according to her testimony, she has been sober. She has a daughter now, and that never. So anytime somebody loses a child, any other children, that never, you can never replace like that. That's not, your heart continues to break for the child that was taken from you. And so I'm open and honest about any leanings that I have when I cover cases. And so far, I think the prosecution has done a phenomenal job putting forth a really, really strong case. I think the medical examiner did a really good job just talking about the fact that there's no way that sepsis could have caused those injuries. There's no way when Brianna dropped Corey off, Corey was healthy based on that video that accidentally recorded. Thank goodness we have that accidental video. Hopefully I've been very clear that the treadmill, it does not sound like that incident had anything, because that was 10 days before Corey's death. And those are two separate incidents, that something happened in, like, when Corey was in Mr. In Christopher's care. That's the allegation. That's what, that's what he's been charged with. And from where I stand, that seems to be where the evidence is pointing. So the defendant comes off as emotionally immature to me. He comes off as very self-centered. He comes off entitled. He comes off very angry. And those things, to me, I think it speaks more about him and the mom, because I think, so dad is retired law enforcement. Like, dad knew they're recording this call. Like, you saying these things, like, this is, like, you need to stop. Like, let's don't talk about the case. We're already talking to your attorney. The parents kept trying to get him to stop, and it sounds like he kept going. And to me, that says more about Christopher's need for control and his need to desperately be heard in this way that ended up hurting him in the long run. To me, that was just consequences. I think at the time of the incident, I think only the youngest, I want to say, is it Donnie? Y'all know I'm bad with names. I want to say there was only one child that might have still been in the house. I'm not sure. So whether or not he takes the stand, I think ultimately that will be his decision. I think his lawyer will make a recommendation. Danny, thank you. Y'all know I'm bad. I'm bad with names. Yes, Danny. Danny is his name. But will Christopher take the stand? If I was his lawyer, I would not recommend it. I don't think that he can manage his emotions when he's cross-examined. I don't know that he can. And based on what he tried to elicit from his mom, because will he tell the truth? Will he come across credible to the jury? Because if he tries to say something that he was trying to get his mom to say, if I was the prosecution, I would enter that as, I would play the video of what he was trying to get his mom to say. And to me, that would make his testimony come across less credible. If he doesn't think things are going well for him, he might pull a Murdaugh. He might pull, I've covered a few other people that have testified that have had similar personality traits that it did not go well for them at all. I don't think it would. And if he takes the stand, what's he going to say about that treadmill video? Like, if he takes a stand, he would have to answer questions about all of it, I think. And so if he does, I won't cancel any clients, but I will, if he like, if y'all see him on the stand, come to my page and see when I have something scheduled, because if he takes the stand, I will definitely be going live. I will definitely cover it very soon after he testifies, because I'm going to have some thoughts. I'm definitely going to have some thoughts. I need to head to my next appointment. Thank y'all so much for joining me. Somebody mentioned the Sebastian Rogers case, and I don't believe there are charges still. I thought did the father lawyer up or stepfather? Somebody got a lawyer, I thought. I'm definitely keeping an eye on it. And I don't think he's been recovered yet, right? I think he's still missing. And so I am definitely following that case. But yeah, I think it would be a bad idea. I don't think he's going to come across compassionate. I don't think it would come across well. But I hope y'all have a good one. I'll see you all no later than Saturday, but we'll see what happens the rest of this week. There's more testimony today. There's more testimony tomorrow. I might do another pop up. We will see. All right. Bye.